Hey folks, I'm attorney Roger P. Foley, and prior to being an attorney, I boxed for several years. Anyone who knows me knows how much I enjoy combat, how much I enjoy the physical fighting aspect, the science behind boxing, the struggle, the training, the preparation, the getting ready for an opponent. Um, it's a one-on-one sport, right? If I improve myself and train and get coached and spar and hit the speed bag and the double end bag and work mitts with my coach and work on my foot technique, work on my fighting technique, work on my combinations, I can be successful. Well, boxing and the law, I like to think, are similar. They're similar in some ways because there's combat. There's one lawyer against another lawyer in regards to a particular case. Unfortunately, it's not just the preparation. Let me click on this picture here. If I'm preparing for a fight, I'm working on combinations. I'm working on different techniques to parry a jab, or to come with their hook and throw off the hook, right? There's certain things that I can prepare for. When I'm in a courtroom, it's a lot different. Why is it different? Because sometimes what I'm fighting for, the facts don't support it. But the client has hired me to fight the fight. And even though I see what's possibly a losing endeavor, I have to figure out by scratching and clawing and punching and trying to create an angle that would allow me to have some level of success. Well, what happens if you have a client that has terrible facts? What happens if you have a client who gave a confession, who there's video evidence of, where there's individual witnesses to the crime? What do you do then? Well, it makes it a lot more difficult um, to fight, because now it's not just how good I am as an individual, and if I prepare against my opponent, can I win? Well, I can be a lot better attorney than my counterpart, but I'm limited on the facts. Let's see if I can try something. I'm going to pause if I can. All right. So as I was saying, what happens? I'm training. I'm working on rules of evidence. I have case law. I'm prepping my argument. I'm going through my cross examination. I'm going through my direct examination. I'm practicing my opening. I'm practicing my closing. I can still lose. Think about that. In boxing, it's a mind game. It's how strong. If you get hit, can you come back harder? Can you avoid other strikes? Can you hit and not be hit? In criminal defense, it's almost like I'm given another boxer's abilities. Maybe that boxer has a good jab, but maybe he has no power in his right hand. Maybe when he throws a hook, he misses. He makes it too short, so he never lands a hook. Well, I'm in control of that boxer's body, that boxer's abilities, but I'm handicapped because I can't do what I can do because I'm limited by the facts of the case. So I've had so many cases like this, folks. I get riled up and I guess where it stems from is you have battles with prosecutors, right? You have battles with opposing counsel, um, and you want to fight. And where I come from, where my strength lies, is in overcoming obstacles and fighting through things and fighting back and throwing punches back, literally and figuratively. Um, so when I have a opposing counsel that says, "Yeah, that's not going to work. I'll give you, 3 years in prison," and I go, "No, I can't accept that. That's like accepting loss. I can't accept loss. I have to fight loss." Well, now the difference between a boxer, right? In that analogy, maybe I'm sparring and my opponent, or I'm in a fight and my opponent hits me with a right hand and knocks me down. 3 years, and I go, no, 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 no. I'm getting back up because it's my will to win, my will to survive, my will to conquer. Well, it's not about my will as a criminal defense attorney. It is to some extent, but I'm at the mercy of my client. So I've had clients where I've said, "Hey, listen, this is a very good trial case. Option one is you take a plea bargain, you get a probation for 2 or 3 years, you get a withhold of adjudication, and you move on with your life." Or option B is, "I've already exhausted the technical arguments. It's a trial case, but hey, you got a, you got some really good facts, and you could be successful in your trial, but it's up to you. You have to make the choice." And the client goes, "Mr. Foley, I appreciate you. I appreciate you going through everything, answering my calls, showing me case law, walking through the arguments. But like you said, if you lose, I'm going to prison." That's hard, folks. I you know, Sometimes I understand, because a client wants to fight generally, but not when they're getting punched back in the face, right? Boxing is a sport where people punch back. So it's really good when people hit the mitts and people hit the bags and they look really great, but there's something to defense. There's something to deal with when you're getting hit back. Your punches. You ever watch someone hit a heavy bag and you go, "Ooh, wow, they could," and then you watch them spar and you're like, it's because they haven't got acclimated to rolling with punches, catching punches, having their arms up, so the punches have to come around their arms, right? They're not used to catching, right, coming rolling, and then shooting a right hand right off of it. They're not used to that. The only way you get used to that is by sparring and competing and fighting, and doing it over and over and over, and practicing things with your sparring partner where you're technique driven as opposed to just trying to, beat the hell out of the other guy. The hardest thing for me as a criminal defense attorney is sometimes I feel like I just want to rah, like I want to punch. I want to punch, 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 and I want to talk some shit, but I can't. Why? Because one, I'm not in a boxing ring, and we'll find out. But I can't tell you how many times a prosecutor gives me an offer, and it's just my competition. Because sometimes, here's the reality, folks. Sometimes the offers that I receive from a prosecutor are legit, right? If my client stabs somebody, if my client, beat the hell out of, his girlfriend or wife, or if the female like stabbed her sister, or someone stole money from their boss, like hundreds of thousands of dollars. I mean, of course, like there's realistic expectations. If you commit a crime, there's some penalty, right? If you get caught, the penalty is not just paying your defense attorney. Your penalty is actually, if your defense attorney can't win, what are you going to get? Are you going to get probation? Are you going to get prison? Are you going to get jail? What are the consequences? Are you going to get community service hours? Are you going to get theft classes? You're going to get batterers intervention classes, anger management, drug and alcohol evaluation, follow-up treatment, outpatient treatment, inpatient treatment, right? There's all of these factors that go in. So sometimes a prosecutor gives me what's probably to the rest of the world reasonable, and I'm like, because there's that fight within me. I don't. No, I'm not taking a knee. No, you just hit me to the belly. But you know what? I'm gonna hold on to you, and I'm gonna get my senses about me, right? And I'm gonna throw right back. But guess what? It's not boxing. I can't do it. I have a client that's sitting behind me that goes either rock and roll, Mr. Foley, do what you do, um, or there's a client behind me that says, no, 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 I can't take any risk. I can't spend another hour in a jail cell, let alone weeks, months, years. Um, and then there's factors of just the case is horrible facts. There's witnesses, there's ID, there's confessions, and you can't win. But the competitive nature of just being a man who was in combat sports for so long, I got to tell you, sometimes I go, oh, like I don't even know what to do because what happens if you don't have the facts? What happens? Let's just here's the great things, right? That happen. Never happens, but you have the shittiest facts, right? Um, and you're offered something ridiculous, and ridiculous meaning probably fair, right? Jail or prison, and your attorney tells you, hey, this is this, or I can go to trial, but I got to tell you the odds are low because of this, this, this. I can create an argument. I can create a theme. If the gloves don't fit, acquit. Right? I can come up with a theme, but at the end of the day, I may not be able to be victorious. What does the client do? The client goes, I need another attorney. I mean, I can't believe this. What are you doing? Right? So, like, then there's that, again, I'm a fighter, and I'm like, dude, are you, like, I'm helping you. So, what do you do as a defense attorney? I don't know. I guess you make a video about it, right? You make a video about the struggles that you have. I want to go. The reality is, I'd like to go on every single trial. I would. I'd like to jam up the criminal justice system and say, yeah, I'm ready. Like, let me take my depots. I take my depots on my felony cases. I file motions on my misdemeanor cases. Let me take a depot. The judge says no, then I just file a motion to suppress, or a motion in limine, or some argument that I can get testimony from, and then just go. I, you know, there was a few years back where I was like, hey man, I'll just I'll just go to trial. Like I want to go to trial. But here's the problem with going to trial. I'm acknowledging it's like going into a sparring session with Mike Tyson in 1986, 87, 88, 89, knowing that I'm out muscled. The facts are against me. He's quicker. The prosecutor may have had more experience or not. I don't know. But there's this fear of the unknown. But in boxing, you're going to take an ass whooping, right? There's no other way to say it. Like, I'm not politically correct. When I'm in boxing, I get into the ring with a sparring partner. I know that I could have a good day, he could have a good day. That's the reality. But the more I practice, the more repetition, the less days I miss, the better my opportunity to be successful in that sparring, to go to other gyms, spar with other guys, and prepare for my tournaments, for my competitions, for my real opponent in the ring. And it's all up to me in boxing. It's all up to me. How much I prepare, my mental focus, my coaching, right? Even coaching, like I've had good coaching, I've had bad coaching, I've had no coaching. It's up to me. Am I in condition? Have I been running my sprints? Am I running, my 400s? Sprint 400, walk 100 meters, sprint another 400, walk 100 meters, sprint another 400. Am I doing that? Am I getting in sparring? In amateur boxing, we had 3 rounds to 5 rounds of boxing. Am I sparring 10 rounds to make sure that there's no way I could be physically tired, regardless of what my opponent brings to the ring? I wish it worked like that in my cases, man. I can prepare and I can file motions, and the judge can go, respectfully denied, Mr. Foley. And It was a good argument. It was interesting. I don't know, but I find I find the state's witnesses credible, and I'm going to have to decline your motion. Then what do I do? Then it's, hey, Mr. Client, would you like to go to trial or not go to trial? Yeah, I want trial. Okay, but let you realize that this is what's good for you. 1, 2, 3. And here's what's bad for you. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. Right? Maybe the odds aren't in the client's favor. So now, although I'm a fighter, I got to protect my client from getting his ass handed to him, from saying, I want a trial, to, hey, sometimes the smart thing is to, I can't even see, I can't even say the words, folks. Sometimes, like in cards, I guess you fold. In boxing, you never fold. In fighting, in combat sports, you don't fold. You do it until you can't do it. So I have that battle within me. Man, I got to tell you, maybe someone watches this video, has no chance, and goes, "Hey, go to trial." And I know the public defenders have that situation. Sometimes their cases are so bad, their fact patterns are so bad, and their client's going, "I want to go to trial," and they're going, "Okay." How can you sharpen your tools if you don't go, right? So for all those people who knock the public defender's office and say, "Oh, listen, they're dealing with horrible facts," could a 5'7", 145-pound guy with no boxing experience, beat the heavyweight champion of the world? No. Could he beat the middleweight champion of the world? No. But in those ass whoopings, that young fighter with really no experience could learn something. Yeah, he could learn how to get an ass whooping, but he could also learn techniques. He could learn movements. A trial attorney who goes to trial can learn, better things to do with picking jurors, right? Do better in voir dire. Can come up with more creative motions in limine. Can come up with more creative arguments. When you have nothing, right? Like, let's say I got this one piece of paper, right? And the state has, I don't know, all of these different things, and the balance is like this. You got to learn something. And that's what I try to do as an attorney to deal with it. Because sometimes it doesn't matter how good I am or how prepared I am, my fact pattern. And sometimes I got to tell you, sometimes I get irked because like a prosecutor will like throw a little dig in there, like, all right, go to trial. That's like a gang coming up to me with 7 people with, they have a bat and they have nunchucks and they have a chain and they got brass knuckles and they talk crap to me and they go, well, just fight us. Come on. Like, and I've actually had those fights where I fought a gang where they did have that stuff and I got my ass whooped. So there's that aggression where I just go, figuratively, not figuratively, I literally go, oh, I just want to punch that prosecutor in the face. What I want to do is I want to stuff the evidence down their throat. I want to, again, not literally, folks, possible thoughts, but I stop myself. I'm getting older, where I just want to go like, hey man, just give me a case. Just give me a case that we both have a legitimate shot. Shit, give me a 60-40 case that I can fight. I almost think that there should be competitions, mock trials for actual attorneys. Every time there's something that's actually picking a jury or cross-examination and it's a live thing, I go. I sign up. I want to be the best I can be. And I know, I know that there's so many hurdles that I have to get over. I know there's so much, let's say I'm here, the ceiling's out of the picture, folks. The ceiling is out of the picture. But if it takes me one step at a day, I don't care if I'm the best guy in the country when I'm 80 years old. I want to be the best. I want to take on the trials. I want to take on the motions. Um, I also got to make a living. If I could just go and work for free, I probably would just to see how good I can be, to take everything. But no, I got to make a living, and I got to have a proportionate time period. So um, anyway, I'm just sharing my thoughts of going from combat, from boxing for, I don't know how long I was in boxing, over 17 years. I always say 17 years, but I really started in seventh and eighth grade, where I kind of got my hands wet, and then I kind of did more in high school. 10th grade, I really put a lot of time into boxing, and then 11th and 12th grade, I did um, my football, and then I went and played football um, in college. And then after college didn't work out, I went back to boxing and then started fighting competitively, and did that until 2004. So um, now I'm at the point where I've had as much time in, probably, with being a criminal defense attorney or a personal injury attorney. Um, but I still, iron sharpens iron, folks. You got to have it. But I'm finding that the criminal justice system is really becoming pushing a paperwork. I'm not getting the trials that I want to get. I want trials. If you're a client, and you want to go to trial, hey, I want to go to trial for you. If you're not happy with your legal team, or you want a second opinion about going to trial, and you want someone that's I'm ready to go. You got to pay me, but I'm willing to do it cheaper than what I normally would do it, because I want to have the battle. I want to give my clients the best that I can bring to the table. Again, I recognize that a lot of trials, state doesn't go to trial, right? Here's the reality, folks. The state attorney does not go to trial if the facts are against them. They just don't, because that's when they plea bargain and offer you deals. And sometimes they offer you a deal when they really don't have a good shot at trial. But that's sort of the modus operandi. Um, all the cases can't go to trial, understood. But man, I wish I could just have a practice where I went to trial. I don't know. Let's see, there's 52 weeks in a year that I went to trial. I don't know, that if I could do half of the year in trial and half doing paperwork, I'd enjoy that. So this is a video about nothing. This is a video about trial, combat, figuring it out. I guess I'm talking about nothing, but I'm going to post it anyway. I'm attorney Roger P. Foley. Thanks for listening. Take care.